Senator Hawley.
Thank you very much, Mr. Chairman. Thanks to the witnesses for being here. Congratulations on your nominations, your respective nominations. Mr. Rossman, if I could just start with you, I want to come back to the compassionate release topic that Senator Tillis was pursuing with you a minute ago, if I could. You wrote during the pandemic a great deal about compassionate release of inmates from jails and prisons, if I'm not mistaken. And I want to talk about first the case U.S. versus Wilson, which you might remember. That's where you sought compassionate release of a prisoner on the basis of his age. I think he was 58, had an underlying health condition, diabetes. He had been sentenced to 4 years in prison for being a felon possessing a firearm. He'd only been in prison, though, about a third of his sentence. The district court denied your motion. The court found that Mr. Wilson's criminal history and the circumstances of the instant offense suggest that he's a danger to the community. Here's what I ask you about. You wrote in your brief that the length of the prison term already served is not dispositive or disqualifying in the compassionate release analysis. And again, he'd only served less than a third of his term. So let me just ask you, do you think that the length of term served, of the prison term served, is relevant in any way to the compassionate release analysis? Give us some indication of your thinking on this.
Thank you, Senator. Certainly the length of the term served is a factor. It is a multi-factor analysis, as all sentencing decisions are. They're individualized decisions where, especially in the compassionate release context, if the individual is eligible, and what that means in the context of that statute is that they've demonstrated an extraordinary and compelling circumstance warranting release, then the court needs to balance a number of sentencing factors, and certainly the amount of time that the individual has served is one of many.
In your view, is there a reasonable percentage of a sentence that ought to be completed before consideration of compassionate release or consideration for compassionate release?
Thank you, Senator. You know, in the abstract, that's a difficult question to answer, and that's because these are such fact-specific inquiries that, again, the amount of time an individual has served, their custodial sentence, certainly a sentence has multiple components. There's a custodial component. There's also supervised release, which is part of the sentence. But the district court has the discretion in these cases to consider all of those factors.
But what about if, well, let's say the defendant only served a day? Would that be too little?
A day, perhaps might be too little, but certainly it would all be a very fact-specific inquiry. And I only hesitate to take a position on this because some of the cases that we were litigating in the compassionate release context involved individuals who were seriously ill and elderly. And so, again, because sentencing, as the Supreme Court has told us, is an individualized process, it's very difficult to answer those questions in the abstract.
Let me ask you about another case, the Moon case, United States versus Moon. You made a similar argument for the pretrial release of a 52-year-old individual male who'd been diagnosed, I think, with head and neck cancer. Now, what got Mr. Moon indicted in that case was his adult children reported that he was threatening them. The government's brief explained that when he was arrested, the defendant, the police found 12 firearms, multiple shotguns, multiple rifles, a loaded handgun underneath his pillow, a revolver, 2 self-made fully automatic machine guns. They also found 2 self-made silencers, a ballistics vest, and 4,602 rounds of ammunition. Neither the machine guns nor the silencers had serial numbers, making them untraceable. So this is somebody who had an arsenal, basically, in his home. We're seeing an epidemic of gun violence in this country. This is somebody who was ready to engage in such violence, and unfortunately also had a history of doing that. His criminal history included willful poisoning, witness-victim bribing, third-degree assault, and harassment. His children were placed in protective custody after they reported him to the police. Moon sent people to go after the children, and one of the people told Moon's roommates, those kids are done for. You argued Mr. Moon should have been released to home detention. I want to ask why you thought the risk of this repeat offender who is clearly dangerous, someone who is stockpiling illegal firearms, why would that why would the danger to the community be outweighed by, in this case, health issues? I mean, give us a sense of how you balance this with a violent offender like Mr. Moon, who is engaged in all manner of violent, illegal activity.
Thank you for that question, Senator. I think that in the abstract, it might seem like there's absolutely no balancing to be done. But when we approach these cases, we're not asking the court to simply release an individual onto the streets. We don't even approach the court unless we have a release plan, something that we believe in good faith under the bounds of the law, we can bring to the court and say, here are terms and conditions that the probation department can weigh in on that we believe will satisfy all of the concerns, including the risks to the community. And in Mr. Moon's case in particular, he was suffering from terminal cancer. And at the time that he was arrested and so forth, his cancer treatment was interrupted. And the type of progression that he had, the concern was he would get much, much worse if his treatment wasn't immediately reinstated.
This is my last question, Mr. Chairman. But you, in the case of Mr. Moon, Ms. Rossman, you don't think that somebody like that poses severe danger to the community, a violent felon, someone who has an arsenal in his home, who is threatening his children, is hiring hitmen to go after them? I mean, help me understand why this person doesn't pose such a risk that you would say, sorry, I mean, you have a history here of violent felonies. We're just not going to release you.
Thank you, Senator. I understand the concern, and it's been a long time since I litigated that case, so I don't recall all of the specific facts that you're referencing. But I can assure you that I've never brought a case or an appeal or made an argument to a court that wasn't made in good faith according to the bounds of the law. And in Mr. Moon's case, it was no different. I applied the law that I thought was consistent with the position that I was advancing and asked the court to do its job, which in this context is to exercise its discretion to weigh and balance the appropriate factors. And we didn't prevail in that case, but the argument was made in good faith.
Thank you, Mr. Chairman.
Thank you. I think Senator Kennedy is next.